In the motion eliminated by my count is the Confrontation Clause objection. I did provide the court some case law in that stack. I gave the court it's the final cases. That's Walter v. State, Snow v. State, and I believe Stevenson v. State, and then U.S. v. Tolliver. And the basic substance of those cases is that the Confrontation Clause applies to hearsay and it applies to testimonial. It applies to hearsay that is a testimonial statement. And these cases point out that text messages are informal statements that are not made in anticipation of litigation, and there is just no way to find that a text message made between two private individuals in an informal setting can be testimonial. And then, of course, any statement made by the defendant in the text messages is a statement by a party opponent and is not hearsay. So the Confrontation Clause doubly does not apply to her statements. Any additional statements by other people in the text messages are not being offered for the truth of what they assert, but rather to put the statements of the defendant in context. So those statements are not hearsay either, and they're certainly not testimonial. So in the same way, the Confrontation Clause doubly does not apply to any of the statements in the cell phone extraction. The defense next objection is under Article 3836, that the evidence is not admissible under 3836. Well, I read that argument, I read it as arguing two things. One, that 3836 applies to testimony as opposed to documentary evidence. And then second, that in absence of any evidence that there was a prior relationship between the defendant and Mr. Jean, 3836 doesn't apply. I'll start with that one. 3836 does include an admissibility provision for evidence concerning a prior relationship between the defendant and the victim, but that's not the sole basis for admissibility under 3836. We're not alleging any prior relationship between the defendant and Mr. Jean, so I don't think that objection really applies in this case. And the state was planning to offer testimony about this cell phone dump, but the defense stipulated to the fact of the cell phone dump. So that stipulation is that the testimony would have been offered. So if the defense is trying to limit this to say it can't come in because there's no testimony about it, well, the testimony would have been there, but the defense has already agreed not to have that testimony. With those 2 points aside, 3836 allows testimony regarding all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense. As I mentioned in our discussion of relevance under Rule 401, these messages, these calls, the web history, all of it goes to the defendant's condition of mind at the time of the offense. How tired she was, how not tired she was, what she was actually thinking about, what she was doing, how capable she was to get home safely, but then suddenly she misses all of these clues about where she's at. That goes to her condition of mind at the time of the shooting. And so the state argues that it's admissible under 3836 as well as under 401 and 402. And then finally, the last argument is due process. The defense cites two cases, neither of which are applicable here. Payne v. Tennessee was a death penalty case talking about whether there was prejudice from having a victim character testimony during the punishment phase, and they said there was no due process violation in that case. And then Rankin v. State says that character conformity evidence, that is only character conformity evidence, is not admissible. We're not admitting this for purposes of character conformity. Again, we're not saying the defendant shot Mr. Jean because she's a bad person because of what relationship she was involved in. We're saying the defendant intentionally shot Bob Jean and she wasn't justified, and this evidence proves why she wasn't justified. So there's no due process violation, there's no 3836 violation. In fact, we conform with 3836. There's no Confrontation Clause violation. The evidence is relevant under 401 and 402 and is not substantially outweighed by any prejudicial effect under 403.
Let me just say, the court is aware somewhat about the substance of the text messages and I'm aware of the phone call. What I was not aware of, the web search history. Were you aware of the web search history, Mr. Moe?
We were, Your Honor, and we object to any of that as being relevant. We objected under 403.
Is this a web search on September 6th?
No, Judge, the particular web search that Mr. Mitchell has just told me about is after September, is one of the days after September 6th, the defendant did a search for how to change her phone number, which goes to then confirming that she did change her phone number, which is one of the texts that confirms her identity as the person using the phone.
So that's back to your authentication.
Yes, Judge.
Okay. Does that conclude your objection?
Yes, Judge.
Thank you. Mr. Moe?
And I'll just start the last argument that Mr. Gladden made. Article 38.36, Texas Code of Criminal Procedure, Your Honor, the only potentially relevant part of that article is subpart A. Subpart B would not apply because subpart B goes to, the evidence concerning the defendant and the complainant, the deceased, if there was a family violence that occurred. Subpart A, Your Honor, reads, I'm reading it for a specific reason, in all prosecutions for murder, the state or the defendant shall be permitted to offer testimony as to all relevant facts and circumstances surrounding the killing and the previous relationship existing between the accused and the deceased. That's the first part of subpart A. Together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense. I read the two words together as being conjunctive with the first part, not disjunctive. It's not an or, it's together with, meaning and. So I believe 36A applies only where the parties want to get into evidence concerning the prior relationship of the accused and the deceased. The state just stated in a judicial statement that there was no prior relationship, and we agree. So we don't think 3836 applies at all in this case. During a prior argument, Your Honor, the state had argued that the theory is that the text messages show that Mrs. Guyger was distracted because she was either thinking something good was going to happen that night or something bad was going to happen. Our argument is, Your Honor, that's rank speculation, as I pointed out in my motion, to try to prove up someone's state of mind, what someone was thinking through text messages, can't be allowed. Because not even an expert who testifies as to circumstantial evidence can testify as to, a person, what's going through a person's mind. So we don't think 3836A applies at all in this case. Going back, Your Honor, Mr. Gladden mentioned something about, Miss Guyger being tired and, whether she really was that tired because she was able to drive home. It's never been the defense's contention, Your Honor, that Miss Guyger was in a coma when she was driving. That therefore she didn't know, she was out of her mind, didn't know where she was. It's just that she was simply fatigued and distracted, which caused her to drive to the wrong floor of the parking garage to begin with. So,
but you stated fatigued and distracted.
Well, yeah, for fatigue.
His argument for distraction relates to the text messages and or phone call.
But the problem is, to say that text messages exist and they were distracted is one thing. The state wants to get into the detailed content of those text messages, and some of those contents do go into things that we believe would be so prejudicial that the probative value is outweighed by the prejudicial effect in the 403. Again, concerning her prior relationship with Martin Rivera, we think that's very prejudicial. We think that is the state trying to, whether they intend to or not, trying to cast Ms. Guyger in a bad light, saying that because she did that, then she couldn't have been reasonable in her actions. So again, it's one thing, and let me be clear, Your Honor, the state originally, as it was communicated to me by co-counsel, talked about doing a full cell phone dump. We definitely object to any sort of dump which allows the jury to look at all the data that was extracted leading up to September 6, 2018, on September 6, 2018, and then after September 6, 2018, until the end of the extraction. Now, Mr. Gladden, discusses Tienda versus State. I'm very well aware of that case and all the other cases he mentions. Tienda is a case out of Dallas County through the Fifth Court of Appeals. If the state wants to authenticate a communication through a witness, then the state is entitled to attempt to do that. That's what Tienda says is allowed. But here it appears that the state's trying to dump the cell phone extraction on the court and allow the jury to view the cell phone extraction based on the authentication procedures that are laid out in Tienda. And we object to that because we don't believe that's a proper way of authenticating. The only thing we've stipulated to, Your Honor, is that there was a cell phone extraction performed in this case. We're not stipulating to any contents of that extraction. And just be clear on that. So if, let's say, there's a text message on a certain day, or let's say a web search on a certain day, per Tienda, like someone like Mr. Sloss can only testify that that occurred on that cell phone. He can't put that into context. Context is what's important here, Your Honor. And I'll close, on my 401 argument. Context is important. Context would be made through witnesses, live witnesses, not through a series of text messages with the argument, well, if you look at these text messages, you can probably figure out really what was going on here. And that's what we really object to, Your Honor. Obviously, again, if let's say there's a text message between Ms. Guyger and Mr. Rivera, and the state puts Mr. Rivera on the stand, Mr. Rivera can testify, yes, I received that text or I sent that text message. Okay. That's what Tienda says. That's part of authentication. Whether it's relevant goes to whether it's relevant to the facts of the case with regards to the essential elements of the offense of murder or any lesser included. We're objecting and saying that it wouldn't be relevant unless the proper context came up when there was someone on the stand testifying as to that context. And that's my objection, Your Honor.
Yes, Mr. Black.
May I respond to that, Judge?
Yes, sir.
Judge, in Butler v. State, which is a 2015 Court of Criminal Appeals case I gave to the court, the defense counsel has a copy too. On page 6 of the PDF, it's the first full paragraph on that page 6. It's on page 602 of the Southwest Reporter opinion. The court says, authenticating evidence may be direct or circumstantial, and that the state may bridge any logical gap and permit a proper inference that the purported author sent the message. That evidence might include the message's appearance, content, substance, internal patterns, or other distinctive characteristics. And so I would just disagree with Mr. Molla that the court and the jury are allowed to consider the substance of the messages themselves in determining whether they are what we purport them to be, which is messages from the defendant. I just want to add 2 additional responses because I neglected to make this argument the first time. One, the evidence, in addition to being relevant under 401 and 3836, is also relevant under 404B and properly relevant under 404B as evidence tending to show a lack of accident or mistake, as well as the defendant's intent and state of mind. So these are permissible non-character purposes under 404B that the evidence is admissible for. And then finally, Judge, Mr. Molla says that this evidence to prove the defendant's state of mind would be rank speculation. I would agree with Mr. Molla. We can't put an expert on the stand and say, in my expert opinion, the defendant's state of mind was such and such based on this evidence. So this evidence is circumstantial evidence of the defendant's state of mind for the jury to consider, and the jury's fact finder can make rational inferences from the circumstantial evidence, and that includes the substance of what the defendant wrote.
May I briefly respond to that argument? Your Honor, Butler, I want to make sure I'm thinking of the same Butler case. Butler was an aggravated kidnapping case where the state, using Tienda, it's not a new case law or new theory that the Court of Criminal Appeals came up with in 2015. Aggravated kidnapping case where the state put the complainant, Ms. Salas, on the stand to testify about the aggravated kidnapping. Through Ms. Salas, the state admitted electronic communication between her and the defendant. So again, context. The context was established by putting the person on the stand who actually received the text message when involved in communications, remembering the case correctly, and therefore those messages were deemed admissible because they were put in context, not simply because there was a data dump and the state said, well, although we don't have the complainant here and the defendant is not testifying, take a look at these text messages.
I'm just glancing at Butler, and I'm not quite sure that's what the court had. If there's no further argument, I'm going to take a brief recess, and I'll let you know my ruling concerning the text messages, phone calls, and web search history.
Judge, can I make one point on that, Judge, just briefly? We're not at this point offering the entire extraction, okay? I just want to make sure. Okay.
It is my understanding that the nature of this issue relates to the text messages that were sent on September 6, 2018, and for a few days after September 6, 2018. Is that correct?
Yes.
Yes, Mr. Sherman.
Judge, then, there are many texts, if they're offering, I thought it was just only 9/6, but there's all kinds of texts in the following days. That
Yeah, they mentioned a number that they have excluded privileged. It's my understanding that the texts that you all are in dispute about are those that concern allegedly went from Ms. Guyger to Mr. Rivera and from Mr. Rivera back to Ms. Guyger.
But now, if they're including the 7th, 8th, and 9th, there's text between Ms. Guyger and his sister about a news story about Ms. Guyger's brother showing a white power sign she has known nothing about. That's in there in detail.
I don't know if that would have any relevance to this. I think
There's people's opinions about the media, Ms. Geiger's opinions about a story, people saying hang in there. None of that's relevant, Judge, but there's hundreds of them is what they're offering, and they're highly prejudicial to be taken completely out of context.
Well, maybe I misunderstood the nature of the discussion that you all had with me on Monday of last week. But I thought, in essence, this centered around the text between Ms. Guyger and her partner, Mr. Rivera.
I thought they were just going to offer for the 6th of September, not the...
No, they stated clearly that it was the 6th of September of 2018 and for some days afterwards.
Your Honor,
Am I wrong in that?
I think I can clear this up.
Please do. You all may be seated.
Your Honor, for purposes of testimony concerning the event and everything that Mr. Gladden just spoke to concerning the reasonableness of Ms. Geiger's decisions, her state of mind immediately before, during, and immediately after the commission of the offense. It is the text messages that occur around 5 p.m. until, let's say, 10:30 p.m. on September the 6th, 2018, that are directly and concretely relevant to that particular area of the state's case. The only relevance, Your Honor, that the text messages have beyond that, substantially, are going to be the authentication issues that have been raised. And we didn't get those until Friday, okay? But when it comes to authenticating the context, as Mr. Mola has said, basically they are putting us to proof, circumstantially, that that phone was in the possession of Amber Guyger. And so therefore, it is potentially relevant if the court or the jury has issues concerning the authenticity of who sent it, her conversations with her sister. Her sister's name is Alana Guyger. Her sister does have a person who did make signs that were arguably race-related. I don't see that as having any relevance whatsoever unless they put us to proof that that was her and her on her phone. The fact that she got that message from her sister, that is the relevant portion just as to authentication. But I will tell you, Your Honor, I mean this in good faith. The only interest I have for